Hello, everybody. You've got a secret. Your case is going to trial, and now you don't want to disclose that secret. Can the judge force you? Can the judge compel you to disclose your secret to the jury? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is yes, the judge can force you to disclose that secret. So now, how does this arise? Let's say you've got some deep, dark, hidden secret, right? And now you bring a lawsuit, let's say against your doctor, claiming that he was careless. You claim that your doctor's carelessness was a cause of your injury. And you also claim that your injuries are significant or permanent. This is a claim for medical malpractice. And now you believe that you have a very strong case. You take your case to an attorney. He investigates, he obtains all your medical records, he has your records reviewed by a qualified medical expert, which is a requirement here in New York in order to go forward with a lawsuit on your behalf. And now he does all that. And now, during the course of pretrial discovery, your attorney learns for the very first time that you have this deep, dark, hidden secret that you don't want to tell anybody about. You didn't even want to tell your attorney about. But during the course of meeting with your attorney and the course of his investigation, guess what? He learns about this deep, dark secret of yours. And you have to come clean. You can't hide it, especially from your attorney. And if you didn't tell your attorney, then you'd be ambushing your case as well as your attorney. Why? Because now he'd be at a significant disadvantage. So let me tell you how this comes up and how typically we see this arise. So let's say, for example, in years past, you did something that you were not proud of. And let's say it was an illegal activity. And you got caught, you were arrested, and now you were prosecuted. And either you pled guilty or you went to trial and took a verdict and you were found guilty. And now you serve time. So now years and years later, you suffer injury as a result of a doctor's improper medical care. And now what happens? Well, I'll tell you what happens. You are afraid. You are afraid to disclose the fact that you are doing that illegal activity. You are afraid to disclose the fact that you were arrested and afraid that you were convicted of this crime. You are a felon. You are a convicted felon. And you don't want that to tarnish your medical malpractice lawsuit. It could be any civil lawsuit, an accident case, a wrongful death case, an accident case. So now you believe that if you go ahead and disclose that information, it's going to ruin your entire case. Well, let me share something with you. If you don't disclose it, it will ruin your case. If you don't disclose that information during the pretrial litigation process, it will destroy your credibility. You want to know how? You want to see how? I'll give you a great example. So let's say, for example, you were convicted of a crime, you did time, you served time, maybe a few years in prison, and now, let me just get this microphone straight. Okay. And now you are asked at a question and answer session in your attorney's office, known as a deposition, whether you were ever convicted of a crime. And you, in a knee-jerk reaction, blurt out, "No, I was never convicted of a crime." That's your immediate response. Now, you hadn't told your attorney about this. Your attorney didn't do his research and background information on you, so he has no idea. He's clueless. That is an absolute lie, a 100% lie. Now, what have you done? You think that the defense attorney is never going to find out. You think that it's no big deal, that, hey, it's just a little tiny white lie. What you don't realize you just did was you destroyed your credibility. Because I'll tell you something. Every attorney, every defense attorney does a background search on you. Every single case, the defense attorney and their insurance companies do a background search. And I guarantee you, in their search, if you have been convicted of a crime, they will find that information, find out the details of that information, and now, during your pretrial question and answer session, known as a deposition, which, by the way, carries the same exact weight as if you are testifying at trial. So now, if you go ahead and say, "Hey, I've never been convicted of a crime," well, guess what? The defense attorney isn't going to turn around and say, "But wait a second, I have documents right here that say you were." You know why? Because he's going to spring a trap on you. Not now, but when you go to trial. That's when he's going to spring the trap. And he's going to wait. He's going to wait in hiding. And he's going to do it because at trial, you know what's going to happen? Now, 2 years later, when your case finally gets to trial, you're going to be up on the witness stand. The defense attorney rises up to go ahead and cross-examine you. And he's going to ask very innocently, hey, Mr. Jones, have you ever been convicted of a crime? And you're obviously going to say the same thing you said 2 years earlier during your pretrial question and answer session. Say, no, of course not. And he'll turn around and do one of these Vinny Gambini, my cousin Vinny things. Are you sure? Are you sure you've never been convicted of a crime? And you're going to say, no, of course not. Are you really, really sure? Okay, so then he's going to confront you with the fact that you were, in fact, arrested, you were charged, you were convicted or pled guilty, and then served time. Mr. Jones, isn't it true that on January 1st, 1987, you were arrested for the following illegal activity? No. If you deny it at that point, he's going to take those documents that he has from the court and now show it to the judge and ask the judge to take judicial notice. What does that mean? It means that he wants the judge to recognize that these documents are authentic and true, that they were obtained from the court system, that this person with this name, with this identification information, using the same birth date, the same social security number, the same photo, is in fact the same person accused of these crimes, the same person who did in fact commit these crimes, who pled guilty or was convicted after a trial, the same person who served jail time, and now he's going to admit that into evidence. And guess what? Your credibility is destroyed. All because you turned around and said, no, I was never convicted of anything. Well, now you've got a big, big problem. So let's go back to the original question I raised at the beginning of this video, right? The question was, you've got a deep, dark secret. Can the judge at trial compel you to answer or to talk about that deep, dark secret? The answer is yes, he can. Now, as the person bringing the lawsuit, you have an obligation to put on whatever proof, whatever evidence is necessary in order to go ahead and prove your case. And you should know that in the civil law, the way to prove your case is by showing that you are slightly more likely right than wrong. Now, what does that mean? You don't have to show anything beyond a reasonable doubt. That's for a criminal case. These civil cases, we only have to show that we're ever so slightly more likely right than wrong. Just tip the scales ever so slightly. And if we're able to do that, then guess what? Then you're entitled to a verdict in your favor. And once you're entitled to a verdict in your favor, now the jury will ultimately go on to decide how much money you are to receive as a result of the improper medical care that caused your injury. So what happens, though, if you still don't want to disclose that particular fact about you being convicted of a crime? Well, here's what will happen. You're on the witness stand. You've denied during pretrial testimony that you were ever convicted of any crime. And by the way, you should know that simply because you were arrested at one time is not proof of anything. And a defense attorney cannot use the fact that you were arrested as proof that you did or did not commit a crime. Okay? It's only the proper question is, have you ever been convicted of a crime? That means, did you plead guilty or did a jury find you guilty? If that answer is yes, now you've got that deep, dark secret you don't want to disclose, but guess what? The judge says you have to do it. So here's how this happens. You're on the witness stand. The defense is cross-examining you, and he asks that question. Hey, Mr. Jones, have you ever been convicted of a crime? And you turn to the judge and say, Judge, do I have to answer that? And what do you think the judge is going to say? Yes, Mr. Jones, you do have to answer that. Well, I don't want to answer that. Really? Well, Mr. Jones, you have to answer the question. And now the defense attorney is standing there waiting. The moment you say you don't want to answer the question, the jury knows something's up, right? They know that at that point you're hiding something. They understand that you're hiding something. Then it becomes much more intriguing. And now the jury's interest is piqued. Why is he hiding this information? What is it about his deep, dark secret that he doesn't want to tell the jury about? What does he not want to tell us? And the more you try and fight it, guess what happens? Now the jury gets more concerned, more worried, their level of interest rises, and now they begin to think, what are you really hiding? especially when the judge turns around and says, hey, Mr. Jones, you've got to tell the jury the answer to that question. And if he refuses, here's what the judge can do. The judge can turn around and hold him in contempt of court. Now, what does that mean? What does it mean to hold him in contempt of court? It means that he can fine him monetarily. He can sanction him for refusing to follow the court's order and answer the question. In the most extreme circumstance, he can dismiss the entire medical malpractice case. Why? Why can he do that? Well, the judge has the power to decide what evidence gets admitted before the jury, what documents, what testimony, what witnesses can testify. And the judge has the absolute discretion and the power to turn around and say, listen, if you refuse to answer these questions, the defense is being hampered to show the actual truth of your credibility, the truth of the facts of this case, and because you are putting up a brick wall now that prevents him from getting that information for the jury to evaluate and to consider, well, guess what? Now I'm going to decide that your case is going to be dismissed because you are refusing to follow the court's rules. That can happen in extreme circumstances. But in all likelihood, you've already destroyed your credibility by turning around and not disclosing your deep, dark secret during your pretrial testimony, and now you're doing it again at trial, and now the judge is going to compel you to do that, and if you fail to answer the questions once the judge has ordered you to disclose that answer, now you've got a bigger problem. So why do I share this great information with you today? I share it with you for a number of reasons. But number one, I wanted to give you an inside look at exactly what happens in these civil lawsuits involving accident matters, medical malpractice matters, and even wrongful death matters here in New York. You know, I recognize you're watching this video because it showed up in your Facebook feed. Or, on the other hand, maybe you were actually searching for information about your particular problem that happened here in New York. And now you're watching this. But you have questions, and you have questions that need to be answered. Well, if your matter did in fact happen here in New York, and you do have legal questions that need answers, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day. Bye-bye, everybody.